My name is Howard Sapers. I'm the Executive Director of the Canadian Civil Liberties Association. The CCLA believes that no government should be able to override fundamental rights just because it would be politically convenient. The Quebec government apparently disagrees, and it's trying to score some political points by legislating away religious freedoms. That's why the CCLA is challenging Quebec's Bill 21. Bill 21 has been described as a law about secularism, but it really isn't. It's a law about who gets to participate in public life and who doesn't. Bill 21 is discriminatory. It prohibits certain public sector employees, such as police officers or school teachers or even government lawyers, from wearing religious symbols. Symbols like turbans or hijabs, or yarmulkes or crosses. The Quebec government says that it's doing this because they're trying to guarantee religious neutrality and secularism in public institutions. But instead what they're doing is they're kicking religious freedoms of minority religious communities to the curb. Bill 21 violates religious freedoms, it violates equality rights, and it violates democratic rights that are guaranteed under both the Canadian and the Quebec Charters of Rights and Freedoms. The Quebec government knows this. That's why they're using the notwithstanding clauses of both charters to ensure that their law will remain in effect even though it violates these important charter guarantees. Now, the notwithstanding clause of the Canadian Charter allows a law to override rights for a period of up to 5 years. It's nothing short of a political get-out-of-jail-free card. Our intervention before the Supreme Court of Canada is imminent. In our challenge, we will be pushing back hard against this troubling law.
We tell children in our lives that they can grow up to be anything they want to be, but for a generation of Quebec children, these dreams are being limited by Bill 21. That is why the CCLA, along with our litigation partner and a teacher, are challenging Bill 21 because it infringes religious freedom, equality rights, and democratic principles enshrined in our Constitution. It forces people to choose between their faith and their chosen professions, and no one should have to make that choice. It also sends a message of exclusion to generations of young people that they don't belong in Quebec society because their religious beliefs are visibly different from the majority. We took the Quebec government to court in 2019 to challenge this discriminatory law. Lower courts have already recognized the serious harms caused by Bill 21. But because of the notwithstanding clause, the courts found that their hands were tied. Now, the case is before the Supreme Court of Canada, where the stakes are national. We are asking the Supreme Court of Canada to find that there are limits to how the notwithstanding clause can be used, and these limits can be found within our constitutional architecture. A hearing is scheduled for the week of March 23, 2026, and this is a defining moment for the future of charter rights in Canada. If governments can use the notwithstanding clause without consequence, they won't hesitate to do so time and time again. If our rights and freedoms can so easily be overridden, our charter becomes meaningless. No government should be limiting a child's dreams and their potential.